Welcome to the FDOT Office of Environmental Management's Introduction to Section 106 of the National Historic Preservation Act. This CBT is the first in a series that will cover the Section 106 regulations and FDOT's process for compliance with Section 106 in accordance with the Section 106 Programmatic Agreement, or PA. This CBT will introduce the National Historic Preservation Act and the process for complying with Section 106 as dictated in 36 CFR Part 800. The environmental review, consultation, and other actions required by applicable federal environmental laws described in this training are carried out by FDOT pursuant to 23 U.S.C. Section 327 and a Memorandum of Understanding dated December 14, 2016, executed by the Florida Highway Administration, or FHWA, and FDOT. This course intends to introduce the listener to the National Historic Preservation Act of 1966, introduce general cultural resources terminology, describe the process for complying with Section 106 and a lead agency's obligations under Section 106, and foster an appreciation and awareness for cultural resources concerns throughout the project development process. The National Historic Preservation Act of 1966 sought to ensure that the impacts of growth and development are considered as federal projects are carried out. The passage of the NHPA reflected a growing concern that we were losing the character of our communities as a result of modern development. The NHPA applies to federal actions or federally assisted undertakings, and the purpose is to take into account the effect of an undertaking on any cultural resource that is listed in or eligible for listing in the National Register of Historic Places, or NRHP. Section 106 of the NHPA makes federal agencies assume responsibility for the effects of their projects on historic properties and forces them to be publicly accountable for their decisions. So briefly, Section 106 requires federal agencies to do three main things prior to implementing a project or an undertaking. They have to take into account the effects of their undertaking on historic properties. They have to afford the Advisory Council on Historic Preservation, or ACHP, a reasonable opportunity to comment regarding such an undertaking, and they have to consult. The ACHP, or Council, is an independent U.S. government agency created by the NHPA, whose members are charged with advising the President and Congress on historic preservation, recommending measures to coordinate agency activities, entering into and commenting on Section 106 consultation, and most importantly, developing the regulations that govern the implementation of Section 106. These regulations are found in 36 CFR Part 800 and are essentially the how-to manual for navigating the Section 106 process. Before proceeding, it's important to understand the difference between a cultural resource and a historic property and why this difference is important. The term cultural resource is not defined in federal law. It's an umbrella term that captures any pre-contact or historic district, site, building, structure, or object that may have some importance to people. The term cultural resource is interchangeable with and equally as broad as historic or archaeological resource and historic or archaeological site. The only requirement for a resource to be considered historic is that it must simply be 50 years old or older. Now, a historic property is any cultural resource that is significant. And significant in this case means it is listed on or eligible for listing on the National Register of Historic Places. The National Register is the official list of the nation's historic properties deemed worthy of preservation. This distinction is important because only historic properties are protected under Section 106. The ACHP's regulations lay out a four-step process for compliance with Section 106. Step 1 is initiate the process. Step 2, identify historic properties. Step 3, assess adverse effects. And Step 4, resolve adverse effects. There are two important points to remember regarding this process. First, Section 106 is a consultative process, and consultation is required at every step. This consultation includes the State Historic Preservation Officer, or SHPO, and/or the Tribal Historic Preservation Officer, or THPO, the public, Native American tribes, and any other potentially interested or affected parties. The second thing to remember is that an agency can fulfill their obligations under 106 at any step of the process. It just depends on the specific conditions regarding the undertaking. Generally, the ACHP may deal with over 100,000 undertakings per year, but only 5% end up making it all the way to step 4. In step 1 of the Section 106 process, you will establish the undertaking, coordinate with other reviews, initiate consultation, create a public involvement plan, and notify the SHPO and/or TIPO. Establish the undertaking. The NHPA defines an undertaking as a project, activity, or program that has federal funding or requires a federal approval or permit. This is obviously very broad and covers most types of actions where there's any federal involvement. But if an activity is an undertaking, then the agency must determine if it is a type of activity that has the potential to cause effects on historic properties. If an agency determines that its activity is not an undertaking, or that the undertaking does not have the potential to cause effects, then Section 106 obligations have been fulfilled and they may proceed with the undertaking. That would be your exit point for step 1. Step 1 is also where the agency should plan for their responsibilities under other environmental requirements that may also apply to the development of the undertaking. Compliance with other laws does not substitute for compliance with Section 106, but information developed for these other reviews can be used to fulfill requirements under the Council's regulations. For FDOT projects, it's especially important to coordinate Section 106 compliance with the requirements of NEPA and Section 4F of the US DOT Act. The intent is to streamline these reviews to prevent the duplication of efforts. Next, we are going to initiate consultation. Consultation is central to the Section 106 process, and the first task here is to identify the appropriate participants and to clarify their roles. Consulting parties are the organizations or individuals that federal agencies must consult with. These can include the SHPO or TIPO, Native American tribes, local governments, or the applicants for the federal assistance. We must also make a plan to involve the public. Agencies must seek the views of the public, and we must give the public the opportunity to learn about the project and its effects and afford them the opportunity to express their views. At this stage, we have to plan out the public involvement process and determine how and when to engage with the public. The regulations do not prescribe specific methods for consultation. Instead, they require consultation appropriate to the scale and nature of the undertaking. For FDOT projects, consultation with the public can be accomplished with the department's existing public involvement procedures. Finally, as in every step of the process, step 1 requires consultation with the SHPO and/or TIPO. So at this point, we have established that we have an undertaking with the potential to cause effects to historic properties. We have identified our consulting parties, and we have planned to involve the public. We are ready to move on to the next step of the process. In step 2, we are going to determine the APE, identify historic properties, and as in all 4 steps, we will consult with the SHPO and/or TIPO and involve the public. The area of potential effect, or APE, is the area within which the undertaking may cause alterations in the character or use of historic properties, if any such properties exist. The APE is influenced by the scale and nature of the undertaking and may be different for different kinds of effects caused by the undertaking. The APE should include all project alternatives, all locations that may be subject to ground disturbing activities, including staging or storage areas for materials or equipment, and proposed pond sites. It should also include all locations from which elements of the proposed undertaking may be visible or audible, and all areas where there may be indirect as well as direct effects. You may also choose to delineate archaeological versus historical APEs, since you will likely only be impacting archaeological sites in areas where you are performing ground disturbing work. Let's consider this example where we are reconstructing lanes on this highway within their original footprint. The archaeological APE, shown in yellow, contains all the areas that will be subject to ground disturbing activities. The historic APE in red includes all the adjacent parcels to the back end of their property lines. Now consider how the APE would change if this project included the construction of an elevated roadway. Our archaeological APE remains the same since we are still working within the same general construction footprint, but the historic APE has to be expanded to capture all the areas from where the new elevated roadway will be visible. In order to ensure that your project's APE is appropriate for the undertaking, it should be determined in consultation with SHPO. Consultation ensures that we are not performing surveys of insufficient APEs and risking having to go out and resurvey. Once our APE is established, we can move on to identifying historic properties within the APE. The process of identifying historic properties involves a thorough background review of existing data to identify previously recorded cultural resources and conducting field surveys to locate and record any previously unrecorded cultural resources. Now, if we have cultural resources in our APE, we must evaluate them for significance. Recall that historic properties are cultural resources that are significant, and this significance is determined by its National Register listing status. If the resource is listed on or eligible for listing on the National Register, it's significant, and thus it's a historic property. To evaluate for significance, we use the National Register criteria for evaluation. For a property to be eligible for the National Register, it must meet one or more of the 4 criteria and possess integrity. The actual National Register nomination process is distinct from the Section 106 process and may take years to complete, which is why a resource only needs to be eligible for listing to be considered a historic property and given protection under Section 106. A property that is eligible under Criterion A has an association with an event or pattern in history, such as the bombing of Pearl Harbor. A property that is eligible under Criterion B has an association with significant individuals, like Ford's Theater in Washington, D.C. A property that is eligible under Criterion C is significant because it embodies distinctive characteristics of architecture, engineering, or design, or it represents the work of a master, or it possesses high artistic value, like the Art Deco district in Miami. And a property that is eligible under Criterion D is significant because of its potential to yield information that is important to history or prehistory. This usually applies to archaeological sites. So a property must meet one or more of these criteria, but it also must possess integrity. Integrity is the resource's ability to convey its historic significance through its surviving physical characteristics. When evaluating integrity, we question whether the property still conveys any or some of the listed elements, whether a preservable entity exists, and whether a group that values it could still recognize or use it today. One of the easiest ways for a significant historic building or structure to lose its integrity is to rehab or renovate the building in a way that is not in keeping with its historic character, like the modernized farmhouse pictured here. So, the agency makes the determination of significance and requests concurrence from SHPO. If no historic properties are identified within the APE, then the lead agency makes a determination of no historic properties affected and the Section 106 obligations are fulfilled. That's your exit point for Step 2. If historic properties are identified, then we move on to Step 3 of the Section 106 process. In Step 3 of the process, we are going to apply the criteria of adverse effect to historic properties and consult with the SHPO and/or TIPO and involve the public. An adverse effect is found when an undertaking may alter any of the characteristics of a historic property that qualify it for inclusion in the National Register. So, given that definition, you can see why properly evaluating properties is crucial. If you have a really good idea of why a property is significant, you can consider how it will be affected and whether the effect will be adverse. For example, if you have a roadway that is listed on the National Register, you would think that reconstructing it in place may be an adverse effect. But if that road is significant because of its association with the development of tourism in Florida, which would be Criterion A, then reconstructing it in place doesn't really alter the characteristics that make it significant. Adverse effects do not have to be a certainty. If a project may diminish the integrity of the property, it's considered to have an adverse effect. They do not need to be physical or direct. They must include reasonably foreseeable effects, and they can include cumulative effects like increased vehicle or foot traffic or increased development over time. If the lead agency determines that their project's effects do not meet the criteria of adverse effect, they make a determination of no adverse effect. After concurrence from SHPO and/or TIPO and other consulting parties, the agency can proceed with the undertaking. That is your exit point for step 3. However, if the agency determines that there will be an adverse effect, then they move on to step 4 of the process. In step 4, we attempt to resolve adverse effects. This step includes notifying the ACHP of the adverse effect, developing strategies to avoid, minimize, or mitigate for the adverse effect, and consulting with SHPO and/or TIPO and the public. The regulations stipulate that the lead agency must notify the ACHP if their project is going to have an adverse effect to a historic property, and they must invite the ACHP to comment or participate in consultation. This can now be accomplished through email using the E106 submittal system. Typically, the ACHP will decline the invitation to comment or participate, but they may enter into consultation on particularly complex or contentious projects. If a project is going to have an adverse effect on a historic property, and these effects can't be avoided, then the agency attempts to minimize or mitigate for them. Of course, this happens in consultation with SHPO and/or TIPO and all of the consulting parties. There are many different ways to mitigate for adverse effects, and the process encourages the development of creative mitigation strategies through consultation, but some of the most common measures include recording historic buildings or bridges, and excavation at archaeological sites, also referred to as data recovery. Other forms of mitigation could include public education, interpretive signage, salvage of certain architectural elements for display or for use on the replacement structure. The possibilities are endless as long as SHPO and/or TIPO, the public, and other consulting parties agree that the measures are sufficient. The Tampa Bay Next project is a great example of a mitigation success story. The reconstruction of I-4 and I-275 was going to have an adverse effect on 12 historic districts, but rather than tearing them down, over 60 historic homes were moved to different locations within their original historic districts. The homes were then sold to homeowners with preservation clauses and funds provided for renovations that would preserve the integrity of the structures. So as a result of this mitigation strategy, most of these homes now reflect their historic character and identity more effectively than they did before they were moved. Once the consulting parties have agreed on the strategies to resolve adverse effects, they are memorialized in a Memorandum of Agreement, or MOA. An MOA is a legally binding document that provides the guidelines for project implementation, and once executed, it evidences compliance with the Section 106 process. At this point, the undertaking can proceed according to the stipulations set forth in the MOA. A few final thoughts that are important to keep in mind through the project development process. Maintain a project file. The documents produced throughout the process, including correspondence with SHPO or consulting parties, will be evidence of your compliance with Section 106. Conduct extensive and good faith consultation. It's up to the participants to work towards the best result. And when in doubt, contact your agency cultural resource experts, the SHPO or TIPO's office, or the ACHP. On this final slide, you will find contact information for the Office of Environmental Management's Cultural Resource Coordinators, as well as useful links for navigating the cultural resources compliance process. Thank you for completing the Office of Environmental Management's Introduction to Section 106 of the National Historic Preservation Act, CBT. The next CBT in this series will describe FDOT's internal process for compliance with Section 106 as dictated in the Section 106 Programmatic Agreement.